Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. This particular week, I'd like to talk about waivers, non-immigrant waivers for people who are not applying for the green card, have not received the green card, and are not inadmissible based on various things in regards to lawful permanent residency. A non-immigrant waiver, also known by the code section, a 212D3 waiver, is needed when you are inadmissible to the U.S. for a wide variety of reasons. Almost anything can be waived for a non-immigrant other than if you are a security risk to the United States. So assuming there's no national security risk, then it would be the area of a 212D3 waiver to ultimately get you in. Now, what can be waived? Well, let's say you're inadmissible because you overstayed in the United States for a certain period of time and you are banned from coming back for 3 years, or you overstayed more than a year and you are banned from coming back for 10 years. Let's say that you committed a crime. And that crime falls under the inadmissibility statutes, making it so you cannot get into the United States based on that crime. Let's say you previously committed fraud or misrepresentation. Let's say that you have a deportation order. So as you can see, anything that makes you inadmissible to the United States can get waived through a non-immigrant waiver. Now, given that I said that, there is a big difference between being eligible for a non-immigrant waiver and getting one approved. They are not easy to get approved, but it is very factual specific. I mean, you might be somebody who has 32 different crimes, 13 deportations, and have violated every law under the sun for the last 2 decades. You will find it very difficult, extremely difficult, to get it waived. But then you might be somebody who is subject to the 3-year bar because you may have misunderstood the requirements for being subject to it. You have no criminal history, you didn't violate anything else in the US, and you possibly had a visa here that expired. So in that particular regard, that would be a much easier waiver to be approved. Now, when the waiver is filed, you have to file it in conjunction with a visa. You can't just, go to the border and say, here's my waiver. You have to qualify for a different kind of visa. So whether it's a B2 visitor visa, whether it's an H-1B work visa or an O-1 work visa, whether it is any number of the plethora of types of visas that qualify for someone to come in. That's how it works. Now, it's really a two-step process. The non-immigrant waiver does not go to USCIS, meaning that let's just say, for example, you're going to be applying for a TN visa, work visa, or an H-1B or an H-2B, whatever it is. The work visa will be applied through USCIS. Ultimately, it will hopefully be approved, and then that will be forwarded through their official channels to the U.S. consulate. Now, when it gets to the U.S. consulate, you will have an interview. And once you go for the interview, you, of course, cannot go there. Let's just pretend you're inadmissible because of the 3-year bar because you overstayed for 7 months. You will not be able to just have the interview to show that you qualify for the visa, but you will also have to bring with you the non-immigrant waiver. Now, when you bring it with you, the officer sometimes will decide right there, but more likely than not will, say goodbye and then later review it, also review it with the supervisor, and ultimately issue a decision on whether or not, number one, the visa will be approved, but then number two, whether the non-immigrant waiver will be approved. And if so, then you will be allowed into the United States on the visa with the waiver. Sometimes the non-immigrant waiver is only given a single entry, which means once you get in here, you better do something to maintain your status and not leave. And other times it'll be a multiple entry non-immigrant waiver. Additionally, some visas that do not require prior USCIS approval, you can actually submit at the same time. So, for example, let's say you're going to start your own business in the US under an E2 visa. Well, of course, the E2 that gets sent directly to the US consulate. So you can send the E2 and the waiver directly to the E2 consulate, at which point they can be adjudicated simultaneously. Now, what goes into a non-immigrant waiver? It's not just a form. Okay, I have a lot of people say, well, I filled out this or that form and, expecting an approval tomorrow. It doesn't work like that. The non-immigrant waiver is completely discretionary. Okay, this means that the officer can say no, and that's the end of it. So you have to convince the officer why the waiver should be granted. So of course, for the ones that my firm submits, there's the attorney cover letter, there's declarations, affidavits, supporting evidence. Sometimes there's a psychological report. Other times there are country conditions. There are all kinds of ways. And again, the non-immigrant waiver is very individualized, which means there's not one roadmap for everybody. It has to be made forcefully and strongly based on the individual case. And when it comes right down to it, it's really like a scale. You have the bad stuff on one side. The bad stuff is why you're inadmissible. And you have all the good stuff on the other side. And of course, we try to maximize the good stuff so as to get it approved. Okay, so that would be it for this week. If you like the video, click like, subscribe, and more on the coming weeks.